All right. Good afternoon, everybody. Welcome to our edition. I think we had an overwhelming response, on this specific topic that we're going to be addressing this afternoon. Just some house rules, if I can may just ask you guys just to mute your mic. Obviously, this is a meeting facility, so everybody's mics are or could be on or off. If I can just ask you for courtesy just to mute your mics, and then we can get going as we go along. I think there will be more people joining us. But yeah, it's 12 o'clock, and I would like to welcome you this afternoon to the presentation, and in specific, our guest speaker today, Cornel Swanepoel from CJS Attorneys, also our resident legal eagle, if I call it that, here at Besha, assisting us quite a bit on the body corporate issues and legal issues that the people might have. Also, a person that's been doing quite a bit of training, and the heart is in training as well. To done a couple of training sessions for us on trustees indemnity or trustees liability. So Cornel, welcome, and I'm going to hand it over to you.
All right, thank you very much. Thank you, Saki, and thank you for the opportunity. Welcome to everyone, and thank you for joining us today while we unpack the POPI Act for body corporates and HOAs. Now, as Saki said, my name is Cornel Swanepoel. I'm an attorney specializing in
Zoom meeting
law. Okay, so today we'll be looking at a couple of things. Firstly, I'll give you an introduction and an overview of the Act and what it means for body corporates and HOAs. Things you need to consider, you need to review ultimately what is expected of schemes in compliance with the Act. We will look at the 8 conditions imposed by the Act and how to comply with each one of them. Then we will be looking at the information officer, their role, their responsibility, and the duties and responsibilities of the information officer. And then finally, what documentation you have to put in place by 30 June to adhere to the compliance regulations of the Act. Now, I have to be completely honest with you, legislation is boring, and the POPI Act is no different. So the same provisions gets repeated over and over. But be that as it may, it is still very, very important. So I'm going to try and make this as interesting as possible, but bear with me, there's only so much that we can do. And then I have compiled an information guide for body corporates and HOAs that will be forwarded to all the attendees here today, together with copies of the POPI Act, the regulations, as well as the PIA Act, which is also important and something that we will be discussing today. Now, I will keep it short and sweet. If you have any questions on anything that I have covered here today or in general related to the POPI Act, I will be giving my details at the end of the webinar. You are welcome to send me an email with your questions. And if you need assistance with the documentation and policy documents required for the Act, as we will be discussing, I will be able to assist you with that as well. All right, so let's get started. Saki, I think you can move to the next slide. I actually can move on 2 slides. Mute all the participants.
You know what? I've got another one. Let me use this.
Saki, can I just ask you to mute all the participants if possible?
I'll do that, guys. If we can just ask you guys to just mute. I'm going to try and mute everybody. And just maybe just mute your mic, please.
Yeah, I can't mute anybody from my side, but all right, no, that's no issues. Let's carry on. Saki, I think you can move on to the next one, because this is basically just the introduction that we've covered. So the purpose of the Protection of Information Act, commonly referred to as POPI Act or POPIA, is to protect the personal information of individuals from misuse by other parties who may access such information. Now, Section 114, which commenced last year, the 1st of July, 2020, is of particular importance, as all parties that process personal information have 1 year period of grace from commencement of that regulation to conform to the requirements of the Act and put in place the required processes and procedures in order to ensure compliance, unless this grace period is extended, but I doubt that that will happen. Now, it is important to note that the POPI Act does not operate in isolation to other legislation, but is part of a network of legislation. It must be read in conjunction with Section 32 of the Constitution, supplemented by the Promotion of Access to Information Act, also known as PIA. So the one essentially protects personal information and the other one promotes access to information. Now, the POPI Act must also be read in conjunction with the Sectional Title Schemes Management Act and any other legislation regarding the role of trustees and managing agents in the performance of their duties. Now, the POPI Act do not prohibit responsible parties such as scheme executives or managing agents from sharing data subjects, the owners or residents in the schemes, personal information in every circumstance. You are allowed to deliver information. You just need to do it correctly, not misuse the information, and make it available to everybody without consent from the data subjects. Now, the principle applied should be that a person is entitled to be furnished with any available information that materially affects their interests and that may include personal information of another resident in the scheme. Now, if we look at the data subjects, these are the persons whose information is being requested and kept by the body corporate or the HOA. They have the right to have their personal information processed lawfully in accordance with POPI, as well as a right to object to the information being processed on reasonable grounds related to his or her situation. Now, who are the responsible parties as referred to in the Act? Now, the provisions of POPI need to be complied with by those with access to community schemes members' information and by those that may request such information in terms of the community schemes governance legislation or governance documents. Body corporates, trustees, directors, and appointed managing agents all have a responsibility in terms of various provisions of the Sectional Titles Act, the regulations, the CSOS Act, the regulations of the CSOS Act, to process owners' personal information, thus making them the responsible party. The owners, the tenants, employees, contractors, etc., to whom the personal information will relate will be the data subjects as referred to in the Act. Now, this means that a community scheme must ensure that personal information of owners and tenants and visitors provided to the scheme, for instance, schemes that scan visitors' personal information on their driver's license for access control or require the writing down of information in a visitor's log, is only processed for specific, explicit, defined, and legitimate reasons that relate to the specific functions required by the Sectional Titles Act, and it cannot be used for any different purpose. Now, schemes will have to ensure that the person providing the personal information is fully aware of the purpose for which the details are being required, and it must not intrude on an owner's privacy to an unreasonable extent. They also must ensure that personal information is kept and stored for as long as it is required in a safe control environment, and the information is deleted when it is no longer required. Now, they must ensure that personal information gathered is accurate and complete as required by legislation, and the information must be updated when necessary. Now, a member of a community scheme should be informed on request of where and why the personal information is being kept, and they must have an opportunity to check the information and make amendments if necessary. And then community schemes will have to consider what data they keep, how it's stored, how it's secured, used, and how it is made available to outside parties. They must also ensure that they have appropriate technical security safeguards in place of how the information is stored and managed and securely held for the relevant parties. Now, let's look at what is personal information. Now, the POPI Act will apply to personal information of owners and residents held by managing agents and estate agents or estate managers, especially information that is not on the public domain. Now, personal information has a very wide definition in terms of the Act, and please see my information guide that will be provided to everybody with a full description of what it entails. But essentially, for schemes, this may include full names, identity numbers, email addresses, physical addresses, telephone numbers, location information, financial histories, employment records, and correspondences. So it covers a lot. The Sectional Title Schemes Management Act will also provide a list of information that owners and other parties are reasonably entitled to. All right, now, this is quite important. The Act allows industry and sector leaders such as CSOS and NAMA and even the EEAB to implement code of conducts and conduct rules for compliance with the POPI Act. Now, This has not yet been done, so we will have to wait and see. And hopefully one of these regulators will be able to provide a consolidated document with procedures for handling this particular legislation in conjunction with other legislation governing schemes that can give us exact clarity on what is needed. However, until this is provided, all schemes and HOAs will have to do their part in proving compliance with the POPI Act. All right, so let's get to the conditions of the Act. Sakya, I think you can move to the next slide. Now, Chapter 3 of the Act lists 8 conditions for lawful processing of personal information that every scheme needs to comply with. And this is basically the importance of the Act. Now, firstly, that's accountability. The responsible party must ensure that conditions and all measures set out in the Act that give effect to such conditions are complied with at the time of determining the purpose and means of processing. Now, what does this mean? All schemes need to determine who will be tasked with responsibility of compliance of your body corporate or HOA, as this individual may be held liable for non-compliance in certain situations. Then how will this individual ensure compliance with the POPI Act? And this will require policies and procedures to be in place to ensure the compliance. Then the second condition posed by the Act is processing limitations. Now, this means that information may only be processed in a fair and lawful manner and only with the consent of a data subject. Now, how do you ensure this? Schemes need to determine if the personal information was obtained directly from the data subject. Is the data subject aware that you are gathering his or her information and consented thereto? If the information has been gathered from a third party, has the data subject consented to this information being shared and used by you? And is the information that you are gathering excessive? Remember, only information that is required for a specific purpose for which it was gathered may be stored. You may collect more information than required for the intended use in future if you obtain the necessary consent from the data subjects. Then, thirdly, the Act requires data to be purpose specific. Now, what this means is personal information will only be processed for a specific, explicit, defined, and legitimate reasons. So there's a couple of things that you as information officer or as responsible parties need to ask yourself. For what specific, explicit purpose and lawful purpose is the information being collected? And purpose of this must be documented. Is the data subject aware of the purpose for which the information is being collected? And can you link all personal information collected to legitimate reasons for collecting it? For what time may you retain the personal information? Because remember, personal information may only be used for a specific purpose for which it was gathered, and thereafter it must be destroyed. So this procedures should be covered in your POPI policies and procedures manual. And then how will you track when personal information must be destroyed? For what purpose it was gathered and what date is actually implemented in destroying the data. And then what process will be used to destroy personal information in a manner that prevents its reconstruction after you no longer authorized to retain the records. All right, then the fourth requirement relates to further processing limitations. Now, personal information may not be processed for a secondary purpose unless the processing is compatible with the original purpose. Now, what does this mean? So if you intend to reuse personal information, it should be in accordance with the purpose that it was collected for. Should you want to use existing personal information for another purpose or for a second time, then confirmation from the data subject and consent will be required from them. And this is specifically important for marketing purposes. Information may not be used for direct marketing without the consent of a data subject. Then the fifth condition is information quality. Now, the responsible party must take reasonable steps to ensure that personal information collected is complete, accurate, not misleading, and updated when necessary. So how do you ensure that personal information is reliable and accurate at all times? By obtaining the information directly from the data source. It's always advisable to validate the personal information as it's being captured. And if it's not possible for the data subject to input their own personal information, or if the information is captured from one format to another, from, for example, paper to an IT system, then the information should be sent back to the data subject for validation. Then what process do you have in place to allow data subjects to update their information or withdraw their consent for the information being used? That should also be covered in your policies and procedures manual. Then condition 6 is openness. Now, data subjects whose information you are collecting must be aware that you are collecting such information and for what purpose it is being collected. Now, questions to ask yourself as a managing agent or as trustee: how do you gather personal information from data subjects? What is the process that you are following, and how can you document the consent that they have to give? Also, how do you inform data subjects of the purpose for which the information is actually being gathered by them? And then also important, does data subjects know who the responsible party is in your organization? Remember, when gathering information, data subjects must be given the details of the responsible parties and their contact details, should they be raising any questions. Then they need to know their rights to lodge a complaint with the information regulator, as well as their rights to access their information and object to the processing of some of the information. Everything needs to be covered in a policy document that you have to put in place. Then, if we look at condition 7, security safeguards. Now, this is something that they are really hammering on in practice at the moment. Personal information must be kept secure against risk of loss, unlawful access, interference, modification, unauthorized destruction, and disclosure. Now, to ensure this, what procedure do you have in place to identify any foreseeable risks in losing personal information? They recommend safety and security risk assessments to be done. And you need to have safety and security policies in place in your POPI policies and procedure manual. This is required to prevent personal information from falling into unauthorized hands, to determine which employees are permitted access to personal information and what information they are permitted access to alert you when personal information is accessed or modified without authorization, to identify sources of data breaches and the procedures to follow to neutralize these breaches, and then to ensure that safeguards are continually updated in response to new risks that may arise, and to prevent the reoccurrence of data breaches. And then very importantly, to inform a data subjects that their personal information has been compromised. I mean, this is required. They need to be notified immediately if their information has been compromised. And then the information regulator also needs to be advised of the security breach. Then the last condition is data subject participation. This, I kind of feel that the Act is kind of, saying the same thing over and over again. But be that as it may, data subjects may request their personal information. They may request where the personal information is being held, as well as the process for correction or deletion or changing any of the personal information. Now, what are the data subjects' rights of access to information that's being held by you? What process do you have in place to ensure that their requests are complied with? And the process that you have in place to allow data subjects to correct any information. Again, this should be covered in your POPI policies and procedures manual. And it's the duty and responsibility of the responsible person to ensure that this process is followed. Now, just to recap the conditions for lawful processing of personal information required by schemes and HOAs, they are required to have accountability, to have consent from data subjects to obtain and share personal information, to only collect information required for a specific purpose. Should the information be used for a second time, it must be used for the same purpose, and the data subject must be aware of the continued use. The personal information must be accurate and updated if needs be. Then the data subjects must know their rights and the process for gathering information. Security safeguards must be in place to prevent unauthorized access to information. And then data subjects must have access to their own information and know the process of reviewing or correcting it. Now, if I have to be honest with you, you most likely have been doing it correctly all along, but you are now required to document it. So have procedures in place, have boxes to tick to make sure that information is collected correctly and made available to third parties correctly. All right, so let's move on to the information officer and everything you need to know on the role of the information officer. Now, what is the role of the information officer? The information regulator published guidelines for information officers and deputy information officers. Now, the instructions on how to register your information officer are provided with registration forms in the POPI guidance note, which I will also be sending to all the attendees. But the regulator has an electronic portal for online registrations. I've not personally used it, but registration should be able to be done quite easily on the online format because there's forms to be completed and submitted. So please visit the Information Regulator's website for more details on this, and they will give you step-by-step, instructions on how to register your information officer. Then, who is the information officer and who can be deputies? Now, POPI designates the head of a business as the information officer. Now, the head of a business can delegate his or her responsibilities as information officer to any duly authorized person. However, it is important to note that whoever determines the purpose and means for processing personal information remains ultimately responsible for ensuring that the processing of personal information is done in a lawful manner and retains the accountability and responsibility for any power or function authorized by that person. The information officer may also appoint as many deputy information officers as necessary. Now, once a decision is made to delegate the role of the information officer, the questions may arise whether to appoint somebody internal or external. Now, the information officer of a juristic person, such as a body corporate or an HOA, can be a trustee or a director or any person authorized by that officer, which can be an agent. So managing agents may be appointed as information officers. Now, let's consider the duties and responsibilities of the information officer. Now, remember, information officers need to be registered with the regulator before they can take up their duties. Now, the Act stipulates a couple of general responsibilities, and these include to encourage compliance with POPI, specifically the 8 conditions for lawful processing of personal information, as we've just discussed, and then dealing with requests made from data subjects to update or view their personal information. Then working with the regulator on investigations, should there be any investigations, and then otherwise ensuring compliance with POPI as may be prescribed from time to time. Now, this relates to updates from the regulator or perhaps CSORS or NAMA's notifications that might come up in future. Sorry. All right, then Regulation 4 lists specific responsibilities in addition to these that I've just mentioned for the information officer. And that is to have a compliance framework. Now, this means to develop and implement policies and procedures for compliance with POPI and to ensure that it is monitored and maintained over time. This could be captured in a POPI policy document and procedures manual that outlines who is responsible for what and what conditions and policies apply. Then the information officers should also do a personal information impact assessment to identify where procedures are required and to ensure that adequate measures and standards exist to comply with the conditions of the Act. Then they must ensure that they have a PIA manual. Now, this is a requirement of PIA, the Promotion of Access to Information. And this manual should have actually been in place several years ago. POPI just again reiterates the importance and the requirement to have this in place. Then the information officer must enable data subject participation. They need to develop measures to process requests for information or to have access to information. And this should be covered in your PIA manual as well as your POPI policy document. And then lastly, they are required to do awareness training. Now, they should do internal awareness training sessions regarding the provisions of the POPI Act, regulations made in terms of the Act, codes of conduct when available, whenever that may be, or information obtained from the regulator. This will need to be done on an ongoing basis as the regulator provide updates and guidelines and new regulations, or as the codes of conduct come into existence. All right, so let's look at suitable candidates. While POPI does not specifically set out specific skills and qualifications required for the information officer, realistically, the role should be someone who has a good understanding of information technology. Have a basic legal training is an advantage, but I think the most important is a broad understanding of the scheme's operations. That is why I suggest using the managing agent, because they have this understanding and they work on the scheme's operations on a daily basis. an external information officer will be entitled to charge a fee to oversee and ensure the body corporate's compliance with the POPI Act. If the managing agent is elected as this information officer, this should be agreed on by the body corporate and the agent and contained in an addendum to the managing agent's agreement. All right, now when it comes to offences and penalties, I think everybody has heard, it's been broadcasted all over how, the penalties that will be imposed on body corporates. I'm not going to go over all the offences and penalties, as this is captured in my information guide that will be sent to you, but it is important to note that an information officer or responsible party may, on conviction, be held criminally liable for fines reaching up to 10 million rand or imprisonment. Now, the offences that carry the highest penalties mostly relate to fraudulent and intentional actions and gross negligence in compliance with the conditions. Generally lacking a policy or procedure here or there will most likely not carry a hefty fine. But bear in mind that ignorance is not an excuse. POPI compliance has been broadcasted everywhere the past year, and especially the last couple of months. So claiming that you didn't know or choosing to disregard it might just land you with a hefty fine. So rather be safe than sorry. All right, Saki, we can move to the last one. So what documentation do you have to have in place by 30 June? We were looking at the documentation required by body corporates and HOAs to ensure compliance. Now, firstly, you need to have a copy of the Act, of the Protection of Personal Information Act and the regulations, as well as a copy of the Promotion of Access to Information Act on hand. Then the guidance note on information officers that was issued by the information regulator. This is a very handy document to have, and I recommend that you have this, just a copy in place for your information officer. Then, as I discussed, a PIA manual as required by Section 51 of PIA. This is a must and should actually already be in place. So make a plan if not already. And then to show that you have policies and procedures in place to comply with POPI, you need a POPI policies and procedures document or manual setting out the body corporate's compliance framework and the measures to process personal information. As I discussed, everything needs to be documented. So if it is queried, you have this document to prove that, no, these are the steps and the measures that I have followed as body corporate or HOA to comply with the Act. And then both these documents should be made available to owners and tenants and employees so they know this is the process, these are my rights, and this is the process to be followed. And then you need to amend or add addendums to your managing agent agreement or any other stakeholder agreement, any of the parties who process personal information on your behalf. You need to make sure those agreements are amended to be compliant with the POPI Act. And then the information officer is required to complete a personal impact assessment, and documentational proof of this is required. We can assist you with the drafting of the PIA manual and customized POPI and policies procedure documents, as well as the necessary addendums to your managing agent's agreements. But I think everything else that you need to know is in the information guide that I'm sure Saki and Besho will be forwarding to all the attendees after this webinar. And yeah, that's basically it in a nutshell. That's it from me. Thank you very much for the opportunity. I hope you took in something that I discussed here today. All right, thank you. Back to you, Saki.
Oh, great. Thank you so much, Cornell. I think, this is very informative. I think, for specifically now, cut off 30th of June. What we will do is that if you could just send us your email address to the email that you registered for this seminar. I'll just repeat, it's sco@bestsure.co.za. sco@bestsure.co.za, and then we will send you the information guide as well. And then obviously the contact details for Cornell will be there for you to then communicate directly with her should you need other information as well. Ladies and gentlemen, this brings us to the end of this seminar. We will be sending it through to you, and thank you so much once again, Cornell, for your time. Really appreciate it, and then we will see you soon again.
Thank you very much. Yeah, as I mentioned, any questions, just pop me an email and I'll be happy to answer you.
Awesome.